Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh and hello. So today we will discuss about our case review regarding case Petronas Sdn Bhd versus DWZ Industry. So before we begin, let us introduce our team first. So firstly, my name is Amir Hakim Johari, metric number 2310073.
My name is Muhammad Zawawi bin Zulkifli and my metric number is 2317319.
Hi, my name is Muhammad Adi Iskandar bin Muhammad Sharif and my metric number is 2319853.
My name is Muhammad Nafis bin Kamarul Zaman and my metric number is 2314701.
My name is Nurani Syahmi Azarfan bin Azhar, metric number 2313899.
So for the next part for our presentation, I will be explaining about the material fact for this case. So the plaintiff, who is Petronas Gas Sdn Bhd, engaged in the separation, transportation and distribution of the natural gas components, brought a legal action against the first and the second defendant. The first defendant, a subsidiary to the second defendant, operated a factory adjacent to the plaintiff's land, specializing in surface finishing for metal parts and providing cleaning, washing and electroplating services. So the plaintiff alleged negligence, nuisance, trespass and breach of statutory duties by the defendants due to the discharge of industrial effluents from the factory. So it damaging the plaintiff gas pipeline located beneath their land, specifically at the points of Z74 and Z75. Although the pipeline damage occurred at Z74, closer to the factory, the defendant argued it was due to the lack of heat shrink and acidic soil. The court held that the defendant was responsible for breaching their duty of care as they failed to prevent acidic industrial effluent discharge onto the plaintiff's land. The defendant admitted negligence and trespass, constructing fittings without permission. Meanwhile, trespass liability was established, making private nuisance a secondary claim. Strict liability under Rylands versus Fletcher applied to the non-natural use of land, holding the defendants accountable for the escape of harmful effluent. The second defendant was implicated, being directly involved in the operation and sharing common directors. So both defendants were deemed liable.
Alright, without further ado, we would like to discuss regarding the issue of this case. First, the issue that can be constructed, that can be analysed regarding this case is whether DWZ Industries can be sued under negligence. Second, whether the act of DWZ Industries itself of discharging a chemical substance into another land without consent from them can be sued under trespass. And third, whether the conduct of DWZ Industries constitute a strict liability. And last but not least, whether the act of DWZ Industries constitute and can be sued under private nuisance. Now, the parties who involved in this case was Petronas Gas Berhad acting as a plaintiff, meanwhile DWZ Industries Johor Sdn Bhd acting as the defendant. The name of the judge who conduct a trial who heard this case was C. Mi Chunjing.
Without wasting time, I will proceed to the legal principles and rationale disciplinary. So I will explain to you how to establish negligence. One must prove duty of care, breach and damage. The neighbourhood principle, as seen in Donohue versus Stevenson, emphasizes a duty of care to neighbours. So in this case, the proximity of the defendant's factory to the plaintiff land established a clear relationship. So then the Caparo test, assessing foreseeability, proximity and fairness, supports with the duty of care imposition. So it was foreseeable that discharging highly acidic effluent could harm the neighbour's property. So by imposing this duty, it's fair and reasonable for protecting both individuals' interests and the environment. So let's move on to the breach of duty. So in this case, the defendants failed to exercise reasonable care, allowing acidic effluent discharge. The breach is evident in their ineffective wastewater treatment, leading to the environmental charges. Thus, deliberate trespass and violations of the Environmental Quality Act showcase a complete disregard for responsibility, causing severe damage. Then let's shift to trespass. In the case of Ellis vs Lotus Anchor 1874, underscores that any intrusion constitutes a trespass. DW2, as the second defendant, confirms that defendants' construction and discharge on the plaintiff's land without consent, violating property rights. This established actionable trespass requiring no further proof of special damage.
Okay, next is regarding strict liability. Established in Rylands versus Fletcher defines strict liability as holding individuals responsible for any consequences because of hazardous activities without fault or negligence. In this case, the defendants violated strict rules by storing harmful industrial waste improperly and releasing it onto nearby lands, making them liable under strict liability. Moving on to the vicarious liability, it arises when one party is partially responsible for another's negligence. In the specific case, the court found the landowner directly involved in running a factory that caused harm, holding them responsible for the industrial waste release due to their close business relationship with factory. Next is regarding private nuisance, defined as unreasonable interference with land use. We will examine cases like Project Lebuh Raya Utara Selatan versus Kim Seng Enterprise and also Devi versus Harlow Corporation. In a similar case, the defendants' unauthorized construction and discharge of industrial effluent on the plaintiff land constitute the private nuisance, thus resulting in damages.
Next, we continue to the commentary part. In conclusion, the legal analysis of Petronas Gas Sdn Bhd against DWZ industry and reveals complex questions related to negligence, trespass, strict liability, and private nuisance. Beginning with negligence, the examination of duty of care, possibility, proximity, and fairness established that DWZ industry had a clear duty of care towards Petronas Sdn Bhd. The breach of duty is evident in the defendant's failure to operate the waste water treatment plant effectively, resulting in the discharge of the highly acidic industrial effluent onto the plaintiff's land. This negligence is further highlighted by the defendant's deliberate trespass and disregard for environmental responsibility, leading to severe damage. Turning to trespass, the defendant's unauthorized construction of the fitting on the plaintiff lands and subsequent discharge of the industrial effluent without the consent constitute actionable trespass per se. The case of Ellis against Lostoff Iron Corporation 1874 underlines the significance of property rights and boundaries, reinforcing the defendant's liability in this context. In the aspect of strict liability, the application of Reliance against Fletcher 1866 principle holds DWZ industry responsible for the consequences of collecting and improperly managing hazardous industrial waste. The defendant's deviation from the proper waste treatment procedures and their impact on the nearby waters, including the plaintiff's land, solidify their liability under strict rules. Considering vicarious liability, the court's assessment of the owner, the lands directly involved when in the running the factory's activities establish joint responsibility. Both of the owner and the factory are deemed responsible for the discharge of industrial waste, emphasizing the interconnectedness of their operations. Lastly, private nuisance is evident in the actions of DWZ Industries as the construction of the fitting without consent and the discharge of the industrial effluent damage to the plaintiff's land, constituting unreasonable interference with the Petronas Gas Sdn Bhd use the enjoyment of their property. Drawing parallels with Project Lebuh Raya Utara Selatan Sdn Bhd against Kim Seng Enterprise Kedah Sdn Bhd and Devi against Harlow Corporation 1957, the defendant's action aligned with the criteria of private nuisance. As the legal analysis unfolds, it becomes apparent that DWZ industry may face legal consequence under multiple legal doctrine, highlighting the intricate challenge and implication for both parties in this case. That's all from us. Thank you and Assalamualaikum warahmatullahi wabarakatuh.